Welcome to the latest in our series of International Legitimacy Talks. I'm delighted today to welcome Professor Samantha Besson, who is a professor at the Collège de France in Paris and a professor of public, international and European Union law at the University of Freiburg. Welcome, Professor Besson. You're here today to present a paper which you say carries forward Dworkin's work in international law in his seminal piece that was published in 2013. Could you just tell us a little bit about how you came across this paper, what you made of it, and maybe how Dworkin's account fits into more general theories of international law?
Okay, so two questions there.
Yeah.
So the first one is that it took everyone by surprise because we didn't really expect Dworkin to be writing on this topic, and all of a sudden he was. And the paper was made even more interesting by the fact that it was published posthumously, so this made it really interesting. I was sent the paper by a friend of mine who said, look, you've been quoted in one of the footnotes saying something you don't mean, so that made the paper interesting. But besides all this, I think it's an amazing paper. The only sad thing is that he's not here anymore to discuss it with us and maybe take it further, because there's a lot in the paper, and I think there's a lot that could have been developed in different set of papers had there been time. So I think this is how I came across the paper. And of course, being interested in Dworkin's work on equality, I was very curious to see what he would make of equality in a more global or world setting. So how does it fit among other theories of international law? That's your question. I suppose if you're interested in issues of legal positivism versus other theories of law, you'd be interested in having what the other theories of law would make of international law. But since we've moved away from the legal positivism versus other theories of law debate, I think that's not the main interest in the paper. I think what makes the paper interesting is how it situates international law in relationship to the state, which many other theories of international law don't do those days. So I think that's what caught my eye and made it interesting.
So one of the things that's striking about the paper, and also the way you carried forward, for many people I think would be the fact that he has a sort of paradigm of legitimacy that's connected to coercion, right? So the context within which we require legitimacy is where coercion exists or is applied, and that creates demands for legitimacy. But I think for many people, thinking especially about international law, international organizations, they would say, well, where is the coercion there, right? There's no world state, there's no army, there's no world police force. How can we square that circle of linking coercion to the legitimacy of international law in the absence of such institutions and features?
I think this is why people didn't think Dworkin had anything to say about international law, precisely for the reasons you've just described. But I think what's beautiful about the paper is that he says, well, the coercion is not where you expect it. The coercion is actually in the state. The states are the enforcers of international law. And we know it is the case for treaty law, interstate law, but also the laws that are produced within international organizations. States are the main agents and enforcers of that law. So by bringing back international law within the realm of states enforcing law, I think he brings back international law squarely within the issues that are of interest to him, which are associative obligations, democracy, equality, in the enforcement of law.
So there's a sense in which states here are sort of the agents of international law. They're the coercive hard edge of it, but they should be considered a part of it.
To be careful with the term agent, because we tend to use it to cover all sorts of different things. But yes.
Okay, another feature of Dworkin's paper, but I think particularly in your paper, is this emphasizing the idea of a political account of the international legitimacy, of the legitimacy of international law. Can you unpack that a little bit for us? Can you explain what you mean by that?
So the way Dworkin constructs this paper is in reaction to what he sees as the dominant account of the legitimacy of international law, which is consent-based. And he says this doesn't work for different reasons, and let's imagine, or let's construct another account, another set of principles of justification of the authority of international law. And because he's always been interested in political legitimacy, and I am as well, this is the kind of legitimacy he's thinking about for international law. But this doesn't mean you could not think of other kinds of legitimacy for international law as competing grounds of legitimacy. But given that he's interested in political legitimacy, and I am as well, that's what I take in the paper. So his main argument is that states' right to rule actually depends and relies on a title that's given through international law. That international law principles will be the ones underpinning much of the justification of the legitimacy of the authority of states and their laws. And I think this is, I think this is correct, and for the different reasons I push forward in the paper and try to bring a little further than what he's done. I think he doesn't tell us much about this two-tier legitimacy that he describes. I mean, he talks about the legitimacy of states and political legitimacy being at the core of what's international law is about. But he also mentions another kind of mysterious, non-political legitimacy of the system in general that would also matter for states, and it doesn't tell us much about that second tier of legitimacy, and that's what I thought intriguing about the paper. So that's one of the things I try to push forward a little further and unpack.
Yeah.
In my own ways. I mean, I'm not sure he'd agree, or that's one of the things that I thought was interesting. Another thing that really intrigued me is how dismissive he was to some extent about state sovereignty and the importance of equal sovereignty. So I try to come up with a couple of arguments which I think fits his account, which he could have come up with as well. And the last part of the paper, which I think is the most important for me in my paper, but also somehow the most important for him too, except that he didn't really get much going there, is the institutional order in which states are embedded and which makes states and individual equality possible. And that's where I think most of the work needs to be done, and that's where I spend most of the work in the paper. I don't know if this goes along the lines of...
Yeah, I mean, I suppose, one of the reactions to that would be, okay, there's an important role for state sovereignty and the legitimacy of international law, but then for many people, this would go back to consent-based accounts, right? They would think, of course it's about state sovereignty. It's about the consent of states to be bound by certain rules and obligations, and that's where international law comes from. But that's not what you're trying to do in this paper, right?
Well, what I think Dworkin does in the first part of the paper, which I don't really address in my paper because I agree with his, and many others have made those critiques as well, is that we've misunderstood state consent. I think if state consent boils down to voluntarism, this is not what it's about. It can't be the only ground of validity or legitimacy of international law either. So all the things he says there, I think, have been said by many people since, and I don't think his paper or my paper is about going against those critiques. But the funny thing about the paper is that he doesn't try to come up with another account of state consent that could fit his argument, and I think there is one. And by developing one which fits his argument, one can easily meet your critique, which is to say, well, yes, it looks as if it's compatible with state consent. It's just another kind of state consent. It's state consent as a democratic qualification to the legitimacy of international law. So yes, we should care about states accepting, in certain cases, treaties and so on, but this is for democratic reasons because they are representatives democratically and have a word to say, just as we would have a word to say in a democratic state.
So in a sense, as a presumption in favor, would you say, of the legitimacy of international law, and then democratic sovereignty kind of carves out exceptions to that, or?
That's exactly what it does.
Yeah.
But the paper is not about that, because I've been arguing this elsewhere, but I did mention it because I think it fits what Dworkin had in mind. In fact, there's a part in Dworkin's paper where he says, isn't this amazing? My argument actually gets us to the same results as the dominant state consent account I'm criticizing. And what I'm saying in the paper is that there's no wonder his argument ends up going the same way as a state consent account. It's because, they go together. It's just another kind of state consent. It's another understanding of state consent that we should have.
Now, in the paper, both you and Dwork, and well, particularly I think you in this paper are particularly keen to, I wouldn't say dismiss cosmopolitan accounts, but say that cosmopolitanism is not necessarily the standard of international legitimacy, right? You've already talked about states and sovereignty, and state sovereignty. And there's a question in this about, I suppose in all of these kinds of discussions, the question of politics and what kind of politics do we have when we talk about the political legitimacy of international law. We think of things like a disagreement, about consensus, all these things. And I suppose for some people they would say, look, the politics we're talking about is interstate politics. That's really what we should be looking at. This is classic international relations, right? We don't need anything beyond that. Whatever politics happens at the UN or in grand kind of plenipotentiary conferences and treaty organizations, that's what we need. That is the politics that supports international law and the legitimacy of international institutions. But that's not what you're talking about here, right?
No.
How would you distinguish your...
And it's not what he's saying either. I mean, he's less open about this than I am, but clearly this is not where I'm going. I don't think anything in what I'm arguing about political legitimacy weds us only to the state. I mean, there can be many other forms of political legitimacy within the state, below the state, cities, cantons, regions, you know, all the different political communities we see happening at the moment. And beyond the state, I mean, the EU, IOs, I mean, he even discusses IOs and certain kinds of IOs. So the political legitimacy I have in mind in the paper and I've been arguing for elsewhere is not limited to the state. And as Foucault said, you know, the state will maybe be, you know, une péripétie de la gouvernementalité, that's what he said. So, you know, eventually, you know, it may no longer be there, but as long as it's there and it serves, you know, this key democratic purpose than it does now, it needs to be accounted for and taken into account in whatever political legitimacy discussions we do. So, I don't think it's very helpful to be a cosmopolitan at the moment, and I don't think it's very helpful even to be a progressive cosmopolitan, as some are. So they're saying, well, you know, we're slowly moving there, so let's argue something that stays with us along the way. As long as the state's here, I think we need to construct arguments along those lines that really take the state seriously and construct democracy around the state. I don't know if this replies to your question.
We must take it seriously, as somebody once said. So just to kind of conclude, I mean, one of the other things that we keep coming up against when we talk about states as having a significant role in legitimacy in international relations is the what about non-democratic states? What about states that violate certain fundamental principles? And there's an understanding both in your paper and in Dworkin's paper that there is a minimal baseline of legitimacy which applies to all states in terms of basic foundational respect for foundational rights and so on. But what do we do with, you know, this is in some ways maybe it goes more towards a direction of ideal theory, because in the world today we know that this isn't the case. So how do we square that circle and saying, okay, states are important, but what about states who just don't conform to these principles or are not interested in?
So this goes to something that's very important to me in my work at the moment, which is not so present in Dworkin's, which is the work I'm doing with José Luis Martí, my colleague from Spain. We're currently working on a more general theory of democratic representation in international lawmaking. And what we really want to work on is not only the multiplicity of public representatives, so cities, cantons, regions, which I mentioned before, so different political communities below and above the state, around the state, of course, as I explained before, but also private representatives, and trying to think of NGOs, corporations, or many of the other private entities, collective entities we have at the moment, which we tend to address or treat as persons, or worse, actors, rather than approaching them as representatives and looking at it as private representatives and looking at how they may compensate for some of the gaps you were mentioning. So the fact that some states are not democratic, some states don't treat us equally as individuals, some states are not deliberative, some states don't respect human rights, and how private representatives can help us compensate those lacks of representation by certain states, but also how to make that private representation work. How can we make sure corporations, benefit or non-benefit private actors actually represent us? You know, they may claim they do, but how do we actually control them? How can we make them, they represent us equally and don't over-represent certain groups of people and in certain regions of the world? How do we make sure they're sufficiently deliberative and so on? So this is what's interesting me at the moment and the work I'm doing with José Luis Martí, and generally constructing institutions around all this complexity in democracy that we have available. So I don't want the fact that I wrote a paper about sovereign states to mean that I'm not interested in those other forms of democratic legitimacy. I just think that as long as the state's there, we shouldn't forget about it. And my fear at the moment is that a lot of scholars working about international legitimacy have been downplaying the states. I mean, we know why, right? The liberal critique, especially in Anglo-American circles, have been dramatic. And it's interesting to notice that in other languages, in Europe, but also elsewhere in the world, there's more and lively research being done about the state. And I think it's time it changes.
Yeah, it's interesting that, you know, the centrality of the state in thinking about international law and international legitimacy, I find depends on where you're coming from, right, and the perspective from which you're viewing it. So just a final question, we ask all our interviewees this question, given that, you know, we're in an age of populism supposedly, and in many ways international law, international organizations are an easy target for populist politics. Do you think this changes how we think about legitimacy at the international level? Do you think it should change how we think about legitimacy at the international level, or do you see these two things as unconnected?
No, they are absolutely connected, and this is how I close the paper, I think. It's precisely because people feel alienated from international law, and I come from a country where people feel very alienated from international law. And coming from a country where we have direct democracy, I think this is really something that signals that we need to take those questions of political legitimacy extremely seriously. We need to make sure people have a word to say and feel represented when our governments, or also when corporations and other groups produce international law standards. And the developments of soft law at the moment is something I'm really interested in. I don't discuss it so much in the paper, but it's something that should also worry us, because it makes international law even more remote from any form of control and representation than the rest and the rest of it. So absolutely, I think we really need to be concerned as democratic theorists, but also as international lawyers.
So in some sense, it's a salutary wake-up call that this is becoming
absolutely
more pressing then.
I mean, I'm really pleased personally, because for a long time, you know, working on democracy and international law sounded like, you know, no one wanted to work about this. But nowadays, everybody's all of a sudden really concerned about democratic legitimacy and international law. So,
yeah. So hopefully, this might be the catalyst for change in how we think about these things for the better. Great. And on that optimistic note, I just want to say thank you very much for joining us today, Professor Besson.
Thanks for having me. Thank you.